Section 34 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 14, The Laws of the Kentish Kings, Part 3. 5. The Laws of King Witred, A.D. 690 to 696. One more chance remains for further information regarding Kentish Vergelds, viz., in the laws of King Witred, who became king of the Kentish men about A.D. 690, and, according to Bede, died A.D. 725. A century had passed since the laws of Ethelbert were enacted in the time of St. Augustine. Britwald was now Archbishop of Canterbury, and at an assembly of church and people, the great men decreed, with the suffrage of all, these dooms, and added them to the lawful customs of the Kentish men. These laws are mainly ecclesiastical, both in their origin and subject. In the first two clauses, the church was declared to be free from gaffles, and the mund bird of the church was declared to be the same as the king's, viz., 50 skillings, as in Ethelbert's laws. There is therefore no marked change in the Kentish currency, though by this time it must have been almost entirely silver so far as any Kentish coinage was concerned. Clause 5 introduces us for the first time in the Kentish laws to the distinction between the Geiskund and the Korslik classes. Gif peish gerverd Geiskund, mannen ofer bis Gemel bihi unrit hamed gainme offer singais bibod 7 biskopes 7 boca dom se pay gebet his driten 100 skilling and eld ret gif hit kerlorsik man say gebet 50 skillings. When it happens to a Githskund man after this gemet that he enters into unlawful marriage against the command of the king and the bishop and the book's doom, let him make bot for it to his lord with 100 skillings according to ancient law. If he be a Kurlsic man, let him make bot with 50 skillings. It would not do to conclude from this single allusion to Githskund and Korslik men that the Kentish division of classic, Earlslick and Korlslick, had given way before the Wessex division of classes, Githskund and Korslik. There had been no interval between this and the last set of Kentish laws long enough to have made likely any radical change in social conditions, and, as the ancient law alluded to was probably ecclesiastical and not especially Kentish, either in its origin or its terms, it would not be wise to build anything upon the use of the word Githskund beyond recognizing the natural tendency of neighboring peoples under the same ecclesiastical influence to approximate in phraseology, especially in regard to matters of general ecclesiastical interest. Clauses which follow, regulating the penalties for work on Sundays or neglect of baptism, or a curl's making offerings to devils without his wife's knowledge, or a man's giving flesh meat to his family on fast days, do not interest us in this inquiry further than as revealing lingering traces of paganism and the ecclesiastical character of these laws of Witred. There are, however, a few clauses which incidentally come within the lines of our inquiry. Clause 8 is especially interesting as showing that when freedom was given by a lord to his man, and he became folk free, still, even though he left the district, his inheritance, his vergeld, and the mund of his family remained with the freedom giver. Gif man his main, and wioft friols gef, say see folk fry, friols gefa, age his urfa iende, vergold 7 mund, par heina sai offer merce par hiwele. If anyone give freedom to his man at the altar, let him be folk free. Let the freedom giver keep the heritage and vergeld and the mund of his family, be he over the march wherever he will. Here tribal custom asserts itself. The freed man, though freed at the altar, is to be folk free, And yet, although folk free and able to go wherever he will, he cannot inherit because he is nobody's heir. He had no free parents from whom to inherit. His lord inherited what his unfree man might leave behind him. The freed man's vergeld, if he were slain, still went to his lord, for he had no free kindred to claim it. His family remained in the lord's mund unless they also had been set free. These points were doubtless all incident to the position of a newly made freedman under Kentish custom, and this enactment was probably needful only to make it clear that freedom given at the altar, whatever churchmen might think, was not to modify the customary rules incident to freedom giving. The effect of the clause is, however, valuable, because for one moment it accidentally lifts the veil and shows that Kentish tribal custom was in these matters much the same as we have found tribal custom elsewhere. And it is particularly valuable as direct evidence that there was a class of freedmen under Kentish customs as everywhere else. There are also the following clauses on oaths. Biscopes word 7 singises, si unlange button ade. 16. A bishop's and a king's word is unimpeachable without an oath. Minstres aldor hein caen in preots caen. 17. A minister's elder clears himself in the same way as a priest. Priost hein clensi salfe sode in his halgum fragle et foran weoft pus quinde irritatum dicu in expo non mentior swilsi diacon heine clense. 18. A priest clears himself by his own declaration in his holy garments before the altar, saying, I speak the truth in Christ, I do not lie, and so also does the deacon. Cleroc feora sum hein clense his hephod gemanse 7 ane his hand on weophod odre estenden ad abaiken. 19. A cleric shall clear himself as one of 4 of his like, with one hand on the altar, the others standing by and accompanying the oath. Geist hein clense silphes aid on weophode swalsi signi peng. 20. A stranger, geist, shall clear himself by his own oath at the altar, and in the same manner as a king's thane. Korslik manhein fawara sum his hephod gemanse en weophod 7 pisa elra adsi unlegne. 21. A Korslik man shall clear himself with 4 of his like at the altar, and the oath of all of these shall be unimpeachable. These statements regarding oaths, like other laws of Whitred, betray their ecclesiastical origin, and following directly after the imposition of penalties for what may be called ecclesiastical sins, very difficult proof, seem to have been inserted with special reference to them. They are interesting, however, as reminding us again that the system of oath helpers was not absent from Kentish custom. Section 20 of this clause is also interesting, which places the stranger, guest, may we not say the king's guest, in the same position as the king's thane as to the validity of his single oath. Both seem to be specially under the king's protection. In the case of the king's thane, on account of his official or military position; in the case of the stranger, probably because of the absence of his kindred. The king being in the place of kin to the stranger, his single oath is accepted. These laws end with clauses referring to theft, more or less closely resembling those so prominent in King Ein's dooms. They state that a thief slain as a thief was to be without vergeld. If a freeman were caught in the act of thieving, the king might either kill him or sell him over sea, or release him on payment of his vergeld. He who should seize and hold him was to be entitled to the half vergeld, or if he were put to death, to 70 skillings. A man coming from far, or a foreigner, went off the public way, who should neither call aloud nor blow a horn, was to be taken to be a thief, and put to death or redeemed by a vergeld. The last clause resembles Ein's S20 so closely as to suggest a common origin. Whitrade 28. Gif feoren cumin man ope framde butan veg ganj seven he pon nader ne harm ne he horn blau for deof he bid to profiane ope to slain ope to aslain. Ein 20. Gif feor cumin man ode fremde butan veg geond voodoo gong seven ne hiram ne horn blaue for deof he bid to profien ode to slane ode to alsean. The close resemblance between these clauses confirms the suggestion that the expression Geithskund in the Kentish laws of Whitred may have been borrowed from Wessex. Nowhere else than in these contemporary laws of Ein and Whitred does the term Geithskund appear, except in the fragments of Mercian law, which may thus belong to the same period. 6. The division of classes under Kentish custom. We have now examined the Kentish law, especially regarding the amount of the vergelds and mundbirds. Although we may not have arrived at absolute certainty, yet some light may have been thrown upon the important matter of the division of classes. So far as the amounts of the vergeld are concerned, the contrast was between the earl and the freeman, the vergeld of the earl being 3 times that of the freeman. But as regards the mundbird, the contrast was between earl and curl. The mundbirds were king 50 Kentish skillings, earl 20 Kentish skillings, curl 6 Kentish skillings. There must evidently be either identity of meaning or much overlapping in the terms freeman and curl. Otherwise, the curl would be without a vergeld and the freeman without a mundbird. And yet, on the other hand, there was probably some reason why the particular words used were chosen in the several clauses, and to a certain extent it may not be far to seek. So far as the word curl had a special sense, it meant the married man, the husband with the homestead and household, like the North Country husbandman with his husbandland. In this special sense, every curl may have been a freeman, but every freeman may not have been a curl. Hence, in the clauses as regards mundbird, the contrast is between the earl and the curl. Both were men with homesteads and households. Unless they had persons under their mund, they could not have had corresponding mundbirds. The freeman who did not happen to be a man with a homestead and household could have no mundbird, because he had no precinct within which his peace could be broken, and no household under his protection. But he could have a vergeld. So again in the clauses quoted relating to injuries done to the servants in the laws of Ethelbert. 14. If a man lie with an earl's barrel, let him make bot with 12 skillings. 16. If a man lie with a curl's barrel, let him make bot with 6 skillings. If with a theo of the second class, 50 skaets. If with one of the third class, 30 skaets. 25. If anyone slay a curl's halfeta, let him pay bot with 6 skillings. The curl in this contrast is again a husbandman with a homestead and a household, and with burls and theos and halfetas under his roof or in his ham. Wherever in the Kentish laws the word curl is used in any other sense, I think the meaning is confined to that of the married man, the husband, as in the phrase husband and wife. So regarded, the division for purposes of mundbird into earlisk and curlisk classes was natural, and so also, for the purposes of vergeld, was the distinction between earl and freeman. As regards the vergeld, we may consider the terms curl and freeman as practically interchangeable, inasmuch as every curl was certainly a freeman, and the unmarried freeman was probably a cadet or member of the household of some earlisk or curlisk man. Continental society included everywhere, as we have seen, such classes as the Roman liti and liberty, composed of strangers and freedmen who had not so far risen in the social scale as to have fully recognized rights of inheritance, and whose vergeld never was of the same amount as that of the full freeman. It is in connection with such classes that the tribal distinction of blood came in. If for the full freeman we were to substitute the word tribesman, with all the background of hindens of kinsmen to fight and to swear for him involved in the term, then from the same point of view we must expect to find it in Kent, as everywhere else, strangers in the blood below the tribesmen, like the Aelts and Altudes and Teogs of the Cymric codes. the feudators of the Brehon laws, if not the liberty and lity of the Gallo-Romans, or perhaps still more nearly to the point, the lacing classes of the Norse laws. We have already found incidental mention of the Kentish freedman. He cannot, after enfranchisement, have been classed as an Esne or a Theo. There would seem to be no other class mentioned to which he could belong, unless it might be that of the Laits of Ethelbert's laws. It is worthwhile, therefore, to recur to the single clause in Ethelbert's laws already quoted respecting the Laits, and to examine it more closely. Within the compass of its few words, there may perhaps be found evidence connecting the status of the Kentish Lait with what we have learned of the status and conditions of the Norse lacing. 26. If a man slay a Lait of the best class, let him pay 80 skillings. If one of the second class, let him pay 60 skillings. Of the third, let him pay 40 skillings. The clause does not mention to whom the payments are to be made, whether to the Lait himself, or, as in the case of the freedman, to his late owner or lord. But the payments are not called Leitgelds, as are the Vergelds of freemen. Looking to the payments themselves, they are graduated for 3 classes of Laits. There were also, under Norse custom, 3 classes of lacings, gradually growing by successive steps towards a higher grade of freedom as kindreds grew up around them and became more and more nearly perfect, till at last the 9th generation from the first freedmen became fully free. Why may not the 3 grades of Kentish Laits have been doing the same? Let us compare the amounts of the payments for the slaying of the 3 classes of Kentish Laits with those for the 3 classes of Norse lacings. We have seen over and over again that the Kentish skilling, regarded as 20 skaets, was an ore or a Roman ounce of silver. Therefore, Kentish payments stated in ounces of silver were as follows. Best class of Lait, 80 ounces of silver. Second class of Lait, 60 ounces of silver. Third class of Lait, 40 ounces of silver. The Norse ore was also in wheat grains a Roman ounce of silver. The Vergelds of the 3 classes of lacings in the Norse laws were as under: Frialskafi, or newly made freedman, 40 ores of silver. Lacing, after making freedom ale, 60 ores of silver. Lacingia, son or highest rank of lacing, whose great-grandfather was a lacing, 80 ores of silver. So that the Vergelds of the 3 classes of Kentish Laits corresponded exactly in amount with those of the 3 classes of Norse lacings when reckoned both in silver. We may further compare these payments for the Kentish Laits with those for the freedmen of the nearly contemporary Bavarian laws. They are stated in gold solidi of 3 tremises, and the Kentish solidus was of only 2 tremises. We have seen that the Bavarian freedman was paid for with 40 solidi, i.e. 60 Kentish skillings. The payment thus corresponded with that for the Kentish Laits of the second class. These correspondences are unexpected and very significant, but the significance is made still more important by the clause in the Laws of Whitred describing the position of the newly made freedman under Kentish custom. The description of his position might almost be taken as a description of the Frialgiafi, or newly made lacing, of the Norse laws. Under Kentish law, the freedman was to be folk free, but the freedom giver was to keep the heritage and Vergeld and Mund of his family, be he over the march wherever he will. This was, as we have seen, almost exactly the position of the Norse lacing before he had made his freedom ale. He had as yet no kindred to swear and to fight for him. He was still under the Mund and protection of his lord. His descendants could only obtain the protection of a kindred and become wholly free from the thermsel of the lord, when in the course of generations a kindred had grown up gradually around them. So, as we have seen, under the Bavarian laws, the freedman's Vergeld went to his lord. Under the Frisian law, the Vergeld of the Litus went to his lord. Under Ruparian law, even the homo generalis, the freedman who became a Frank with a full Vergeld, was recognized as having at first no kindred. If he had no children, his property went to the fisc. And it was not till the 3rd generation that his descendants had full rights of inheritance. We have already found abundant evidence of the continued force of tribal custom and tribal instincts in regard to the importance of kindred, while considering the meaning and function of the hindens in connection with the 12 hind and twi hind classes of the Anglo-Saxon laws. These remarkable correspondences between the position held by the laets in Kent and that of the lacings and freedmen and laity of continental laws, without our making too much of them, may fairly be taken as additional evidence of the tenacity of tribal custom in these matters. End of section 34.